Who can guide us on where we ended the last lecture we had? Members, is anyone able to guide us on where we ended the last lecture we had? So we are looking at, yes, Hazel?
Oh, you can continue, sir.
Yes, Hazel, you can guide us on where we ended the last lecture we had?
The last lecture we had, well, the last two lectures that we had, we were discussing really the broad interpretation of what a public body is. And then the last lesson, it was the narrow interpretation of what a public body is in regards to the judicial review purposes. And we had looked at case law. I remember last lesson, it was R with versus disciplinary committee of the Jockey Club.
Ex parte the Aga Khan, huh?
Yes.
Okay, that's very good. Okay, did I give you any assignments?
Yes, you did.
I did, very good. I can see people here were hoping that I would not remember. They wanted to say no. Yeah, was saying she forgot. All right, what was the assignment? Hazel, do you remember what the assignment was?
You had asked us what are the 3 grounds for judicial review.
Yeah. We said we should look at the 3 grounds on which an application for judicial review would actually be brought. Yeah, the three grounds on which an application for judicial review would be brought. So before you start identifying those grounds, Caspar, we need to understand one thing, that these grounds, they actually go together with specific reliefs. These grounds, they go together with specific reliefs. A relief is also known as a remedy, but the term remedy is a general term. A relief is something that is specific. Yeah, so a remedy is a solution to the problem, but there are also what are known as specific solutions to the problem. The certain problem, exactly. That's the relief, specific relief. Yeah. So the remedy is the solution. The remedy is the solution. To this solution, there are now specific solutions known as reliefs, a specific relief. So the grounds, members, that we said we should basically go and identify on which an application for judicial review would be brought. These grounds operate with their own specific reliefs. It's very imperative that we actually are able to identify the ground and its own specific relief. Because if you don't do that, you'll be going to court and you are applying for judicial review on a ground perhaps of illegality, or on this ground, let me not start mentioning it. They are applying for judicial review on this ground, and yet what you are seeking as a relief is this, which may not necessarily apply to the grounds on which you have made the application for judicial review. So it's imperative that even as we look at these grounds, the purpose, the reason why, that's the ground, isn't it? The reason why you have applied for judicial review. Even as you apply for that, it's imperative that equally you know what relief I am to pray for. In court, we say my prayer. It is therefore my prayer, your lordships, that you find for my client in this manner, you find for my client in this manner. It's a prayer. We don't say request. In court, we say my prayer. So now, saying that, we have to identify the different grounds. We say there are basically 3 grounds, and these grounds are itemized under Section 30 of the Supreme Court Act of 1980. the one we looked at first when we started looking at judicial review. When we started looking at judicial review, we identified also what the legal framework is for judicial review. What we established is that the legal framework for judicial review is actually the Supreme Court Act of 1981. It's an English statute. We looked at section 30 there, and we saw the provisions for judicial review. Among the grounds, among the reliefs we saw is an order of mandamus, is an order of certiorari, is an order of prohibition. The court also, the law also allows for an injunctive relief. An injunction also allows for damages, where as a result of a body's actions, which might have led to an applicant suffering a specific damage, an applicant is entitled, when they apply for judicial review, they're entitled to produce evidence of the damage that they have suffered and seek to be compensated damages, to compensate for the damage that has been suffered. Otherwise, the three main reliefs are order of certiorari, also known as a passing order, an order of mandamus, also known as a mandatory order, or an order of prohibition. Now, members, in the law of contracts, which you are doing right now, you will realize that, in fact, what in public law we are referring to as a prohibition order is what in private law is known as an injunction. What is known as an injunction? And I don't know if you know what an order of mandamus is in private law. I don't have any idea. Again, it's the law of contracts. Should have learned about that already. What would you say an order of mandamus is in private law? Sorry? That's what it is. It's a mandatory order. Mandamus, an order of mandamus is also known as a mandatory order. But in contract now, just as we have looked at an injunction, there is also a term for a mandatory order that is used in private law contract. Yes, Kaya? Not very sure. Okay, what were you thinking of? So really a clause in the contract is actually a remedy, specific relief in contract. Nicolette, Hazel, any ideas of that? Caspar, what would you say? Yes, Caspar, what would you say it is? Okay, let's go to the law of contract. Let's just go to the law of contract. How many remedies, how many types of remedies are found in the law of contract? Yes, I know. How many types of remedies are found in contracts? There are two, isn't it? And these two are which and which? That is specifically. How many remedies are found? So there are two. What are these two? Members, which are these two remedies that are found in the law of contracts? Yes, Caspar? Possession. That is a specific relief. It's a specific relief as well. So there are two known as legal remedies, and the other is which one? Equitable remedy. You haven't yet started learning about remedies in contracts. Okay. So there are two different types of remedies in contract. What are known as legal remedies? Now, legal remedies are an entitlement. Damages, for example. Damages, award of damages is a legal remedy. However, there are those that are not legal entitlements, but will be awarded at the discretion of the court in the interest of fairness, known as equitable remedies. So under equitable remedies, that's where an injunction falls, and then equally under equitable remedies is where what is now the synonym, or not synonym, but the equal of mandatory order is in the law of contract, which we refer to as an order of specific rights, an order of specific performance. An order of specific performance. You will learn about that. You will learn about that, of course. All these things that we talk about, you will learn about them in due course. So don't feel threatened, do not feel left behind. No, these are just basics of the law that you are learning. So an order of specific performance is what in public law is known as an order of use to mandate you to do that which you are required or expected to do in a contract. When you are in a contractual agreement, when you are in a contractual agreement, and one of the parties fails, okay, all right, Richard, thank you very much for that notice. One of the parties fails to fulfill his or her obligations to the contract. And you, the aggrieved party, believe that, if they do not fulfill, you are going to suffer some form of damage. You have the right to go to court, and you have the right to go to court and seek the court's endowments by ordering that body or individual to actually act as is expected of them arising from the what? So it's a specific performance. Act to that specific requirement as is provided for in the what? In the contract. So we refer to that, we call it an order of specific performance in the law of contract. Otherwise, in public law, that is what we refer to as an order of mandamus. Okay. So now let's just identify these grounds. One is which one? One of these three grounds, which one can bring an application for judicial review. One is which one? Yes, Kyla. Illegality. Illegality. So the first ground, members, is the ground of illegality. First, we list all of them down, and then after that, we shall start explaining them. So the first ground is illegality. Very good. What is the next ground? What is the next ground, members? Nompumelelo, what is the next ground? Nompumelelo?
I don't know if I'm going to put it in procedural unfairness.
Okay, procedural unfairness. Okay. Procedural unfairness. Okay.
Or procedural.
They are both correct. Yes, of course, procedural unfairness. Let's look at procedural improprieties. So procedural unfairness, and let's look at procedural improprieties. So the second ground is procedural impropriety. The second ground is procedural impropriety. Yes, Kyla? Yes? Irrationality. Irrationality, also known as Wainsbury unreasonableness. which also falls under procedural unfairness. Which also falls under, but the name by which it is known in the law is irrationality or Wainsbury unreasonableness. Now, the reason why it is referred to as Wainsbury unreasonableness is simply because this unreasonableness is in the Wainsbury sense. The reason why it is referred to as Wainsbury unreasonableness is because it is unreasonableness in the Wainsbury sense, meaning it is not unreasonable ordinarily, but there is a test that has to be established for you to say that indeed this is unreasonable. And that test was established in the case of Associated Provincial Picture Houses versus Wainsbury Corporation. I'll give you the names. Wainsbury Corporation. So it is from there, it's from that case that it is known as the Wainsbury unreasonableness. So it is not ordinarily, it is not unreasonable in the ordinary meaning of the word, no, but it is unreasonable as had been established, meaning you need to look at the points that have been put up in the case of Associated Provincial Picture Houses versus Wainsbury Corporation. Once you have satisfied those points, then you will say indeed it is what? Unreasonable. If you can't satisfy those points, you cannot say it is unreasonable, basically. So that is what is known as Wainsbury unreasonableness or irrationality. Now, each one of these grounds, members, was established in very, very important case law. And these are cases that you should never, ever forget. These are very, very important cases that we should never, ever forget. So each of the three grounds has case law. Each of the three grounds has case law. And when we speak again about the specific relief, each of these three grounds has its own specific relief. So for example, you cannot bring an application for judicial review on the basis of illegality, and yet you are asking for the relief of an order of mandamus. Cannot do that. When the ground of illegality has its own specific relief. The ground of procedural impropriety has its own specific reliefs. So equally does the ground of irrationality or Wainsbury Corporation has its own specific reliefs. Now, let us zero in on each and every one of them, starting with illegality. I like to use the terminology, it means what it just says. It is just what it says. It is just what it says. Illegality. It is just what it says. It is an illegality. Let me ask this question. When you say something is illegal, what do you mean, members? When you say that something is illegal, what exactly do we mean?
It is outside the realm of law.
It's outside the realm of the law. It's outside the realm of the law. Would you like to clarify that point?
So in these cases, where agencies, these agencies are established by laws, like a law that tells them what and what to do. So when they find themselves acting out of those laws, this is when you create illegality because they are not acting in a lawful manner. Whatever they're doing is not what was intended.
Okay, so Nomumero says that they are acting outside the confines of the law. That's one of the things about illegality. What is the other? What is the other aspect of illegality, members? What could be the other aspect of illegality? So one is what Mkumelo has just explained to us. This body is acting, but its actions are not in accord with what the law actually provides. We say, therefore, that this body has acted illegally. Hey, what is the other aspect of illegality?
So, illegality has a ground for judiciary, pertains to two doctrine, the doctrine of the
Huh?
and procedural doctrine, which has to
Okay.
be following the record.
Now, that one is a different ground. Like, what you have talked about is what you have given as a ground. It's procedural impropriety, which I will look at. Now, here we are just focusing on this ground known as illegality. We're just looking at this ground and we're saying that there are two ways in which illegality come about. One is what Mkumelo has just pointed out, which is that the body is acting outside the realm of authority that, or outside what the law, accords it to act. Then we say there is another. Which is this other? Yes, Pastor.
Which was that
That they're not what? They're not abusing their power. What do you mean, Pastor? When you say they're not abusing their power, what exactly do you mean? What does abusing one's power mean? Pastor has brought about the interesting point to make sure that they're not abusing their power. What is abusing one's power? Okay, so it's what she's saying, yes. So you have a power, isn't it? You have a power, but you are using it for things that you have no authority to use that power. Isn't it? That's abuse of power. You're exercising your power over things that you have absolutely no authority to exercise upon. So that is why we're doing it. So the other component of illegality is where you actually have no authority whatsoever to act as your power. So here is where there is power, but you are exercising it not in accordance with what the law permits you to. Then the other is where you actually have no authority whatsoever. You purport to have authority and you act as though you have that authority. That's illegality. Now, is that acting against natural justice? Okay, Angel says acting against natural justice. Angel, would you like to come in and just clarify the point, that interesting point that you have raised? Angel says acting contrary to natural justice. Angel, would you like to come in and share with us that point, please? Angel? Not now. Okay, not now. Angel doesn't want to speak just now. Okay, so members, when we speak about illegality, like I said, it means just what I said. It means it's illegal. Something which is illegal is something that one has no authority to do, yet they have done it. Or something they purport to have authority, but the manner in which they do it is not in accordance with how the law allows them to do it. We have two cases. And one is a Zambian case, one is an English case. The English case took place in 1921. The English case took place in 1921, whereas the Zambian case took place in 2009. Yes,
So these cases are cases where the agent has power.
illegality. They basically acted in one, they acted without authority to act. Yes. And then in the other, they acted purporting to have acted in accordance with, but the law established that they did not actually have the authority to act in the manner So the first case, members, is the celebrated case. It's a classical case. The celebrated case of Attorney General versus Fuham Corporation. The celebrated case of Attorney General versus Fuham Corporation, 1929. Attorney General versus Fuham Corporation, 1929.
So,
Yes, you do.
this for problem one.
Fuham, Fulham. Attorney General versus Fuham Corporation, like the Fulham Football Club.
Yeah.
Right, yeah. Attorney General versus Fuham Corporation, 1929. The other is the Daniel case of. See, the Daniel case is such an interesting case. You know, such an interesting case. It's a very recent case. 2019 is really recent. That's a case of William Harrington. William Harrington. Case of William Harrington versus Dora Sevilla. William Harrington versus Dora Sevilla. S-I-L-I-Y-A. Sevilla. Dora Sevilla and the Attorney General. The Attorney General was the current Chief Justice. The Attorney General at the time is now the current Chief Justice. Yeah. His Lordship, Mr. Justice Mumba Arira. Now, let us start by looking at the case of Fuham Corporation.
So the year of this case is
2009. Yeah, 2009. Let's start by looking at the Fuham Corporation case. Now, in Fuham, the local authority, Fuham, pursuant or purportedly acting pursuant to provisions of the Public Wash Houses Act, purportedly acting pursuant to the provisions of the Public Wash Houses Act. That act required of local authorities. That act of parliament required of local authorities to establish what are known as public wash houses. Laundrettes, they are called today. They are called laundrettes. Where, you know, a person who does not have a washing machine. You know, our friends, washing machines are now being made to be more like, you know, it's a necessity. You know, a washing machine with our friends in these European countries. It's a necessity. But especially during that time, my suspicion was that, you know, during that time, the age of industrialization was just, you know, strengthened. And technology had not yet advanced that much. So soaps that were being made at the time, my suspicion is that they have been affecting the chemical, they have been affecting people's plants as they washed. So people somehow were being affected by that. The government decided to pass a law known as the Public Wash Houses Act, which law required every local authority to establish what are known as public wash houses. Now, these public wash houses are laundries, like I said, where there are washing machines And you, as a member of the general public, if you don't have a washing machine, you don't have to do this. You go with your clothes to that public wash house. You put your clothes in the washing machine. You slot in a coin. Depending on how long for you want to wash, you insert the number of coins there. If it is 1 hour, you put the number of coins there. Those are the facilities that exist in these countries, right? And it's not, we are living in the same age. It is not a foreign thing. These are the facilities that we should have here. If only we needed to in Africa. If only we needed to. These are the things. People shouldn't be doing chapa. You know, it's about the desire. Do we desire those things? If we do, let us demand of them from our government. After all, we have elected them to be there to deliver these services that we want them to be delivering to us. So anyway, so the law requires simply that when you go to use these public wash houses, the only thing you should do is to insert in the machine a coin, and then you go. You go. Depending on how long for, the coins that you have inserted will wash, you come back and you collect your what? Your laundry, and you go back home. Simple. However, what Fulham Corporation now decided to do was, wow, it's a very interesting idea. We actually perhaps make some money out of this exercise. And we come up with another thing, addition to what we are supposed to do. Perhaps we can make some money out of it. Why don't we introduce a scheme? A scheme that is going to be so attractive, perhaps. They say it to the housewife, and they call it an answer the problem of the housewife. Introduce a scheme, what they refer to as an answer to the problem of the housewife, where they say you don't need to wait at the laundrette for the machine to finish washing. All you need now to do is get a basket. So every laundrette operating within the jurisdiction of Fulham Corporation, we shall now introduce baskets, washing baskets. When you come here, you buy that washing basket, you put your clothes there, you leave your clothes there. In addition to the purchase of the washing basket, you will also pay a small token, which is going to be used now to pay a person that is going to be employed in each one of these laundry facilities to be doing the washing for you. So now, addition therefore to the money that you insert in the machine, for the machine to start washing, you'd also require to buy a basket. You'd also require to pay for the services of the person that will be employed to be working there. Now, that facility of establishing public wash house members was meant for the poor. It was meant for those that could not afford to buy a washing machine for themselves. But then the government comes up with a law requiring you to establish public wash houses, and that the only expense that the users of that facility should be incurring is to insert a coin there, after which they do the machine does the washing, and that's it. Now you are saying buy a basket. Addition to the basket, pay for this person now that is going to be employed. Some people complained. No. We don't think this is what the government intended. We don't think this is what the law requires. So what do? They complained, and the complaint reached the Attorney General's office. The complaint reached the Attorney General's office. And the Attorney General sought an application for judicial review against Fuham Corporation for doing something that they reported they had the power to actually do, pursuant to the provisions of the Public Waterhouses Act. And the matter went to court, of course. The matter went to court, and in the courts of law, the court ruled that what Fuham Corporation had done was an illegality. Let's look at the case. And are you looking at the case right now? All right. Do you want to share with us? Read it. Just read it now, please, so that everyone is able to get what you are looking at there. You can read for us.
Okay. Let me open it to the front.
And read loudly so that Nicolette can hear you.
This website is telling me to sign in.
It wants you to sign in. All right, members, we're just waiting for Nompumelelo to find to get to the case so that she can then read it for us. Not yet found, you know, Nompumelelo?
It's a small summary.
The summary is there. I have already given the facts, so just the holding would be okay. You can just tell us what the holding of the case basically was, and yeah, can read us what the holding of the case basically was, and then let me also get it here. Have you got there, Melilo? Yes, just find the case, and then I'll let you know where to start reading from. If you've got the case, you can let us know. Yeah. What about the one you found earlier? Just disappeared.
So I was like this. So I was reading from. I didn't click to specific websites.
Okay.
So when I'm clicking to specific websites, it wants me to
Sign
sign
in.
up.
Sign up, yes. Okay. All right. Let's see here. Let's see.
Hello. Let me try to read through.
Okay, is that Angel?
Yes, sir.
Okay, Angel, you've got the case. Okay, Angel, you can read the case for us.
But I think it is a summary, but I'll proceed.
Yes, just a summary. We have already narrated what the facts in the case were, so just the summary should do.
Okay, so Bath and Wash Houses Act 1846 gave the Fulham Corporation power to establish wash houses. The corporation operated wash houses with 60 trophies where people could bring in their only with their own soap and have it washed. However, the washing scheme changed in 1920. Under the new scheme, customer had to buy a bag to put the clothes in, then had to leave the bag of clothes with the corporation and return for it after the wash house employees washed them. Until then, until the return, what happened to the clothes was out of control, was out of his control. Issue. Attorney General, this is Fulham Corporation. Attorney General challenged the illegality of the new scheme and applied for an injunction to restrain its operation. Held. The Attorney General's claim succeeded. Above all, the court held that the corporation had gone beyond its statutory duty in that it was subsidizing its operations with the ratepayers' money. Therefore, the court granted injunction. That is an instance in which operations are conducted by persons who have not their own pocket to consider, but who have behind them what they regard as the unlimited or nearly unlimited pursuit of the ratepayers. This was the breach of the fiduciary duty. I think that is where this summary ends, sir.
Thank you very much, Angel. There, thank you very much. Indeed, what you have read there is enough. You know, what you have read is enough for us to get the information that we wanted to get from there. So the case of Fulham Corporation is the classical case, members, when we talk about the aspect of illegality. In there, from what we have read or heard, and you're reading, the court ruled that the local authority had no authority, legal authority, to introduce a scheme, reporting to have introduced that scheme under provisions of a law. It was indisputable, of course, that the local authority had certain powers to exercise under provisions of the Public Wash Houses Act. However, just the particular power that they exercised is what the court ruled they actually did not have the power to do. And therefore, the court granted what is known as a quashing order. You know, the court granted a quashing order and eventually an injunctive relief, prohibiting or preventing the local authority from exercising that authority in future that they did not actually have the power to exercise in accordance with the provisions of the law. So the case of Associated Attorney General versus Fulham Corporation is a classical case, members, when it comes to the aspect of illegality. It's a classical case when it basically comes to the issue of illegality. Okay, let us look at the Zambian case. Let us look at the Zambian case. Now, the Zambian case is an interesting case because of the name. And what I mean when I say because of the name is simply because you would think that William Harrington was applying for judicial review. William Harrington in the Zambian case was not actually applying for judicial review. The one that applied for judicial review was Honorable Dora Silia. The one that applied for judicial review in the case of William Harrington versus Dora Silia and the Attorney General, the one that applied for judicial review was Dora Silia. Now, this case started when Dora Sidia was the Minister of Transport and Communication in 2009, when President Rupiah Banda was President of the Republic of Zambia, of course, appointed her, and pursuant to the policy of the government, initially started by the late President Levi Mwanawasa, whom President Rupiah Banda succeeded when the late President Mwanawasa died in office. The policies that the government, the MMD government had then, was a policy of PPP. The policy of PPP, public-private partnership. That policy, we have, of course, continued with it even now. It has basically been going on from MMD, PF, into this new government that we have, not new, rather, the current government that we have. The public-private partnership projects have been going on, where instead of the government having to 100% privatize these public entities, they will part privatize. And then the government would remain with a certain percentage of shares in those entities. They would privatize majority shares, majority stake in those companies, and the government would basically remain with a certain percentage of shares. Now, what happened in 2009 was that the government wanted to part privatize Zamtel. Zamtel is one of the mobile service providers and also the only company, I think, that offers landlines in Zambia here. It also has a private mobile network section. It's a public company then, and the government wanted to do a part privatization of that company. However, before the part privatization could be done, the government needed to know what the true value of Zamtel actually was. And for that to happen, the government needed to do an evaluation of the assets of Zamtel to ascertain or establish the actual value of that company. So to again do the evaluation, the government had to award a contract to a company to do the evaluation. Now, in Zambia here, as in Zimbabwe, as in South Africa, and as in other countries where procedures in terms of how decisions are made in public administration, there are legal requirements that prescribe the manner in which certain decisions are to be arrived at. So what transpired in that case was this. The government needed to award a contract to a company to do an assessment or an evaluation of the assets that Zamtel had so as to establish exactly what the true value of Zamtel was before they could do a part privatization. Now, to award such a contract, the government needed to follow certain steps or procedure. Among them was to float a tender in the public newspapers, inviting interested bidders to bid for the delivery or provision of this service that the government needed of doing an evaluation. Now, the government overlooked that requirement in the public procurement laws of the country that require that any contract to which the government is involved that is worth $2 million and above, the Attorney General's advice must be sought and consent of the Attorney General must be given. That was the law at the time, as it is today. So what it meant was that a minister could not and can still not, without the consent of the Attorney General, give a tender to a company without having to go through the process of what? Of inviting bids to come from other interested what? Bidders. But that's what happened. So Honorable Doris Bia decided to do what? To award this contract for the evaluation of Zamtel. She unilaterally awarded a contract to RP Capital Solution of the Cayman Islands, a contract worth $2 million, without having to follow the laid down procedures. Ordinarily, of course, that is procedural impropriety, isn't it, on the part of the minister. So she did that, and I remember in the Post newspapers at the time, the Attorney General wrote an article. No, he didn't write an article because he's a member of cabinet, so he can't communicate by articles. He had written to the minister, and what he wrote apparently leaked, and it found itself in the Post newspaper, where it says it is illegal to award a contract without having to go through the process of what? Tender. The Attorney General himself was quoted as having said that. Well, the minister, I think, was already so much convinced and well bent on awarding that contract to RP Capital Solution. So she went ahead nonetheless, notwithstanding what had been said, the Attorney General had said. She went ahead and awarded that contract to RP Capital Solution of the Cayman Islands. So that was one issue of concern by the minister. 1 point. Secondly, the minister had decided again unilaterally to cancel and revoke a contract that had duly been awarded to a company to install radar services at what used to be known as the Lusaka International Airport, which is now known as Kenneth Kaunda International Airport. So the minister decided to revoke that contract and award it to another company again unilaterally, without having to go through the process of what? Of tendering. Second consent. Thirdly, again the minister, it was contended that she had given a loan facility to her constituency of Petauke on understanding that the moment CDF was released, she would be refunded the money. The money it was alleged she had given it for purposes of drilling borehole. For that personal money, it was held. And unfortunately, later information filtered that when she sought to be refunded, she had in fact asked for more than she had given. Three things, therefore. Now, in Zambia, there is a law which is also found in Zimbabwe, which is found in Botswana, which is found in Britain. There is a law known as the Parliamentary and the Ministerial Code of Conduct Act. The Parliamentary and Ministerial Code of Conduct Act. Now, this law specifically, members, this law specifically prohibits a member from deriving a pecuniary advantage from their position as a member. provisions of the Parliamentary and Ministerial Code of Conduct Act prohibit a member from deriving a pecuniary advantage from his or her ministerial or parliamentary position. And the law says that any person who suspects or who alleges that a member has breached this provision of the Parliamentary and Ministerial Code of Conduct Act, the law allows that person who alleges to write to the Chief Justice, highlighting the particulars of the alleged breach of the Act, and that once the Chief Justice received that petition from any member of the general public, the Chief Justice shall set up a tribunal.
So any member.
Any person, or any member of the public can be you, can be me, any person. You just write a letter to the Chief Justice highlighting the alleged breaches that the member has basically committed.
So do they just offer a tribunal without hearing a solid ground? Out of sanctions, they can order a tribunal.
No. So now, once you have written, you need to produce evidence of what you have written. And it is based on the evidence that you are going to adduce that the Chief Justice shall then say that these allegations are what? Substantiated. Otherwise, it will be held, or it will be said that the allegation is merely frivolous or vexatious.
Do I remain anonymous?
No, you won't have to be anonymous, because you actually have to be presenting, you have to go and present. You don't have to worry about it. Those are simple and straightforward matters. They don't need you to be anonymous for. Yes, Nick, Casper.
So what kind of evidence yesterday?
What kind of what?
What kind of evidence?
What kind of evidence? Basically, evidence to prove what you are alleging. Remember, he who alleges bears the burden of proof. So when you allege something, you need to produce evidence to back up what your allegations are. Now, listen to this. So, William Harrington now, a citizen himself, a former Minister of Transport in the Chirwa government, alleged that the minister had breached the provisions of the Parliamentary and Ministerial Code of Conduct Act, that by doing what she did, she was actually trying somehow to derive a pecuniary advantage from her actions or conduct. So William Harrington and some other civil society organizations wrote to the Chief Justice, then his lordship, Mr. Ernest Sakara, indicating what their allegations basically were and producing evidence of that. So once the Chief Justice received that, pursuant now to the provisions of the Parliamentary and Ministerial Code of Conduct Act, the Chief Justice set up what became known as the Chirwa Tribunal. He appointed Justice Chirwa of the Supreme Court and 2 other judges to that tribunal to inquire into the allegations against the Minister of Transport as leveled by Honorable William Harrington and other civil society organizations. So that tribunal, according to the law, is mandated to sit and finish its sitting within 45 days, during which time they will call witnesses and they will also examine the evidence that will be brought before that tribunal. So the evidence that members was brought, according to the tribunal, suggested that Honorable Doris Leah had not breached the Act of Parliament, had not breached the Parliamentary and Ministerial Code of Conduct Act. Now, the tribunal's job, remember, was to investigate matters arising from where? From the Parliamentary and Ministerial Code of Conduct Act. And arising from that act, the tribunal said there is nothing to substantiate the allegations leveled against the minister by Mr. Honorable William Harrington. The tribunal said, however, we find that the minister had acted contrary to Article number 54, Clause 3 of the Constitution, which basically requires the advice and consent of the Attorney General before a minister could act in the manner she acted. And the tribunal says, we therefore find that the Honorable Minister has contravened the Constitution. And that is where the issue now, members, came about. So like I said, the application was not so much by William Harrington, although the party, the name of the case is William Harrington versus Doris Leah and Attorney General. But the application for judicial review itself was not, in fact, by William Harrington. The application for judicial review now was by Honorable Dora Sidia. On what basis? Because now, Honorable Dora Sidia is saying, wait a minute, this tribunal that has been set up to probe my alleged breach of the Parliamentary and Ministerial Code of Conduct Act, it was set up to investigate my actions arising from the Act of Parliament. But this tribunal has now gone beyond its scope of limitation or scope of jurisdiction and has now ventured into investigating matters of what? Of the Constitution. Where did the tribunal get the legal authority to start interpreting the Constitution and saying that I had in fact breached the Constitution? So Doris Leah sought legal advice. And Eric Sirwamba, himself a former Minister of Legal Affairs in the Chilwa government, now running his law firm. So Doris Leah went to Eric Sirwamba and company and sought legal advice. The issue was, has this tribunal acted lawfully? You know, has it acted lawfully by venturing into matters of the Constitution when its jurisdiction is to investigate matters arising from the Parliamentary and Ministerial Code of Conduct Act? Have they acted lawfully or legally? So, of course, first they had to establish that the tribunal is a body that is subject to what? Judicial review. Is it a creature of statute? Yes. It is set up under provisions of the what? Parliamentary and Ministerial Code of Conduct Act. So there they had established it is a creature of statute. So now, what power did it have, or does it have? Does it actually have the power it was exercising? Or perhaps it went beyond the power that it went beyond what power it has to exercise pursuant to the provisions of the law. Now, for us to answer that question, members, let's go and check what their lordship says. Let us check what their lordships said in that case. Let us see what their lordships basically said in that case. So the tribunal or the courts now, on an application for judicial review, when the matter went to the High Court on a judicial review application, when Doris Leah applied for judicial review, the court ruled in her favor. that indeed the tribunal had overstepped its legal authority when it started venturing into matters of a constitution, when in fact the power it had was simply that of inquiring into matters of the Parliamentary and Ministerial Code of Conduct Act. So the court ruled that the tribunal had actually acted illegally. And that finding of a tribunal on the constitution was expanded. Say, this should not be part of the findings in the tribunal. It was therefore what? Removed from the tribunal's finding. Let's see.
So, sir,
Yes, Dr. Mary.
since a crime of horrors was discovered during the time of
Yes.
getting in accordance with the tribunal, but then it's not within the realm of the tribunal. They can charge her with this crime and with a separate.
It wasn't a crime, it was a breach of the Parliamentary and Ministerial Code of Conduct. It's a code of conduct. So it's like, it's just a code. You have acted contrary to the code by which you are supposed to act.
So she can be fined out of this meeting. She can be fined
In a different manner, yes. But now, listen to this. She was not acting in her own accord. She was acting under the prerogative of the president. So that was an instruction, and that is the defense that came about. Because I was acting pursuant to the instructions of the president. So it is not me as an individual, but I was acting by instruction. And therefore it is a prerogative power of the president. So the remedy that was there was the president, the moment the tribunal established that she had acted in violation of the constitution, the only remedy that was there, because at that time, the new constitution that we have now was not even there. Had it been there, the matter could have been taken where? To the constitutional court. But remember, under the 1996 constitution, the only provision for redress was that where there was a breach of the Bill of Rights, article number 28 of the constitution. Now, this action by the minister was not in violation of the Bill of Rights. It was an alleged violation of Article 54, clause 3. And there was no specific remedy for such kind of violation in the Constitution, as opposed to the case now, where you can seek you can petition the Constitutional Court pursuant at 128 now, clause 3, paragraph C. You can do that now. But then you had absolutely no remedy that you could follow, apart from now the president himself having to do it, having to act by dismissing you. But the president could not have dismissed her because she in fact was acting pursuant to the president's what? Instructions. So instead of being dismissed, she was in fact even reappointed. Because when the tribunal was going on, she had to be suspended. She had to be removed from her ministerial position. And after that, after the tribunal finished and cleared her, she was then reappointed as Minister of Education. She was reappointed as Minister of Education. So the tribunal was found to have erred, that it did not have the jurisdiction to venture into matters of the Constitution when it is established under provisions of an Act of Parliament to investigate breaches of the Act of Parliament. And therefore, the court ruled that the tribunal had acted illegally. The court ruled that the tribunal had acted illegally. Now, the question that Nomero has asked was a question, but the tribunal, yes, wrongfully or illegally, had established that she breached the Constitution. So what happened? Well, remember that for any action to be taken, there has to be a prescribed procedure and law. There was nothing prescribed then at the time. There was no constitutional court. So it went without any form of resolution on that. And she continued as minister all the way up to 2011. But she bounced back after the late President Michael Sata. She bounced back again as minister in 2014. So anyway, that is on the aspect of illegality. So those two cases, very, very, very important cases. They illustrate to us very, very succinctly how the ground of illegality actually works. Okay, any questions, members, online members here physically? Has anyone any question at all? Yes, Caspar, you have a question?
You say she asked you for more. And
Yes. It was alleged for an allegation, but there was no evidence to substantiate that. So she was clear on that. Yeah. So she was clear on that as well. Yes, Kyla, you had a question? No? All right. Nonpumelelo, question? Hazel, Angel, Nicolette, do you have any questions? No, okay. No question from Hazel there. No question from Angel there. Nicolette? Okay, we assume no question from Nicolette either. Okay. Now, when you look at the ground of illegality, there's something you need to always be reconciling here, remember? The ground of illegality attracts which specific relief, you think? And why? Members, when you look at the ground of illegality, which specific relief do you think it actually attracts? And why? Which specific relief do you think, do you say it attracts and why? The ground of illegality. Yes, Hazel?
Prohibiting order.
Okay, Hazel, I'll ask that you speak very closely to the mic so that we are able to hear you.
I'm saying a prohibiting order, as it would prevent a public authority from acting beyond its legal powers.
But in this case, Hazel, the body has already acted. You know, in this case, the body has already acted, so you can't prohibit it because it has already acted, and a decision has already been made. Yes, Kyla. Sorry, why security, Kyla? Yes, that's the answer, isn't it? So the remedy, the specific relief, Hazel, in this instance is that of an order of certiorari, which is quashing order, because the decision has been made by a body that did not actually have the power to make that decision. A decision has been made by a body that did not actually have the power to make that decision. In law, we say ab initio. You understand what it means with us? We say ab initio. That decision is invalid. Ab initio. You know what it means? Ab initio. AB A ab initio. I N I C I O. Ab initio. Who can check it out for us? Anyone check it out for us? Remember, who can Google it? Ab initio. Someone to Google it for us and tell us what it means. Is anyone able to check out ab initio for us? Remember, and tell us what it means. It's not ab initio, but ab initio. That's it. Has anyone, members, found it? Who has found it? Who has found the term ab initio? You know, found it from Gomelero?
It's collective name saying initially, like putting a T.
Okay. Should be a T. What does it mean? From the beginning, ab initio. Ab initio, member, simply means from the what? From the beginning. From the way it goes. When a body that does not have the legal authority makes a decision, when a body that does not actually have the legal authority to make a decision, makes a decision, ab initio. Ab initio, the decision that is made by that body is invalid. It just is waiting for the court's pronouncement on that decision to be validated. That's basically what happened. That is what happened in the case of Dora Sibila. So the decision of the tribunal to say that she acted contrary to the constitution ab initio, that decision was invalid. Now, again, we need to reconcile this. People then would say, but isn't it that we have been learning that judicial review is not about the decision made, but the process leading to the decision? But how come then in this case, the decision is the one that has been passed? It is still the process leading to the decision and not the decision. So in this case, you don't see the decision that you are concerned about. The decision simply shouldn't have been allowed to stand. Because they use the wrong process. So they don't have order. Ordinarily, one would have said, why can't they then make an order of mandamus? Mandamus order. You can't make an order of mandamus on a body that does not actually have the power to exercise that authority. Because the tribunal does not have the power to satisfy the matters of the constitution. So you could have ruled, you could have seen that then why didn't the courts, by way of judicial review, order that the body now goes back to the drawing board and start making a decision how to follow the correct channel. What was the correct channel? Correct channel was that then they venture into the matter of the constitution, which ordinarily they do not have the legal authority to do. So after this, the decision of a body made without legal authority is to be declared null and void. Such a decision, members, is to be declared null and void. I didn't read those some statements there. Okay. All right, Angel, sorry about that. So that is about illegality. That is about illegality. So the ground of illegality will always attract the relief of order of certiorari. Quashed. The decision made will be quashed because the body that made it didn't actually have the legal authority to make it. The court will quash. The court will grant or will order certiorari. Okay, let us look at the other ground. Let's look at the other ground. Unless there are questions on the first ground, comments, if there are questions, if there are comments, You can ask now. But if not, let us proceed on to the next ground. So the next ground, members, is what is known as procedural impropriety. The next ground is what is basically known as procedural impropriety. Now, this term, procedural impropriety, is drawn from two terms. This term, procedural impropriety, is basically drawn from two terms. The first term, of course, is procedure, and then the other term is improper, meaning it is looking at now the procedure as followed by a body when arriving at its decision. Now, let's look at this. When we speak about public bodies being creatures of statute, we are saying that this statute by which it is established, among other things, two things it does, this statute, two things it especially does. One is to give it the authority to act, the power that it has. They will derive from where? From the statute, the act of Parliament. Secondly, we say that it is to prescribe the manner in which the powers as conferred on these bodies are to be exercised. That, members, is what especially justifies the existence of the rule of law. Rule in accordance with what? In accordance with the law. The opposite of rule of law, we say, is rule by what? By the whims and caprices of man. Discretion. Now we say that where there is discretion, you can't establish whether what a body has done is right or wrong. What will help us to establish wrongful or otherwise conduct of a body is by looking at the law. So the law, equally, members, the law prescribes the manner in which these public bodies are supposed to make their decisions, the different stages, and what has to happen at each one of those different stages. The law prescribes, so that if you go contrary to the prescribed procedure as prescribed by law, shall then be said that you have acted improperly procedurally. Which procedure? That which is laid down by what? By law. So procedural impropriety, therefore, arises by saying that the manner in which a body conducted itself is contrary to the prescribed procedures as provided for in the law that established this body and conferred on this body the functions and the powers that basically is required to exercise. So we have one very interesting case to that effect, remember, the Zambian case, decided in 1973. We have one very, very, very interesting case decided in 1973. The case of Bedford Chilufya Kangombe, probably known as the Kangombe case. Bedford Chilufya Kangombe versus the Attorney General. Bedford Chilufya Kangombe versus the Attorney General. Anyone familiar with this case, members?
It's which year?
1973. Anyone familiar with that case, members? Okay, no one is familiar with that case. But that's a case that you are supposed to know for purposes of procedural impropriety. That's a case that we are supposed to know. Now, and when you go into the practice of the law, this is what you are learning about. I always tell students that you will not go to the area and start doing advanced law. No. The law that you are learning here is the law that you are going to start applying when you start practicing law. When you go to the area, they'll just teach you how to commence an action, procedures in the commencement of actions in court.
It's Bedford.
Bedford, BED, Bedford, Bedford, Chilufya, Kangombe. The Kangombe case versus the Attorney General. That is an interesting case. You know, that case, members, tells us about the rule of law. When you look at the rule of law, as we had explained it, we looked at the second limb of the rule of law, and we say that no one is right above the law. The second limb of the rule of law, according to Professor Albert Venn Dicey, is that no one should be treated, or rather, all persons should be treated in the same manner before the law, as administered by the courts of law, as established by the regular laws of the land. This case, members, had to do with the president of the Republic of Zambia, then Dr. Kenneth David Kaunda. Now, Mr. Kangombe was a teacher. Bedford Kangombe was a teacher on the Copper Belt. In fact, he was a deputy head of a school on the Copper Belt in Kitwe. 1972, if you recall, the government started the process of Zambia becoming a one-party state. And of course, it's expected and it's understood. But the government at the time did not, of course, want so much opposition. Not that it is okay. That is not the okay part I talked about. That is not the expected part I talked about. The okay part and the expected part I talked about is what I'll be talking about later. But in 1972, just a year prior to that case, Zambia, via President KK, had started the process of amending the constitution, have a one-party state. Now, Mr. Kangombe, a teacher working in the public service as a public servant, he was suspected to be involving himself in opposition political party activities. That is where I say it's understood and it's okay what the government did with regards to him, but not the procedure they followed. Why do I say it is understood and it's okay? Because, members, there is what is known as a civil service code. One of the most important provisions in the civil service code is that as a civil servant, your allegiance is where? Members, anyone, our friends online, our friends here, as a civil servant, your allegiance is to where?
To the government.
To the not just to the government angel, but to the government of the day. That is an important civil service code, members. Now, why is it so important? You people, you need to know that governance, when it comes to governance, It is not ministers that implement the policies of the government. It is the civil servants. The ministers are simply custodians of the policy of what of the government to make sure that the policy is being implemented as the government wants it to be implemented. So ministers do not in fact implement policy. It is the civil servants. So you, as a civil servant, you owe your allegiance to the government of what? Of the day. Now, it is not to mean that you should be supporting the government of the day and that you should be voting for the government of the day. What it means simply is that you should act to advance the agenda of the government of the what? Of the day. Your job is to make sure whether you are in an opposition or not, but your job is to ensure that the agenda of the agenda of the government of the day is being implemented to the fullest without reservation. However, if you have strong reservation, you also have the right to do what? To resign. And you also have the right to resign your civil service what? Job. However, here is now Mr. Bedford Chirusha Kangombe, a teacher in government school, meaning a civil servant, who is supposed to owe allegiance to the government of what? Of a day. He is suspected to be engaging himself in opposition political party activities, being a member of the Zambia African National Congress, led by then Harry Mwanga Lukumbula, the main opposition leader at the time. Now, that information filters to the Secretary to the Cabinet, who recently passed on, Mr. Aaron Muna. This year he passed on, Mr. Aaron Muna. He was Secretary to the Cabinet. And to the Minister of Education. There is this man, he's a deputy head. We understand he's influencing people against the government. He's a civil servant. All right, he can't continue in the civil service then. How do we remove him from the civil service? No, according to the law procedure now comes in, isn't it? Procedure. Procedure requires that a person working as a teacher in the civil service, their removal must be done via the Teaching Service Commission, appointing a tribunal to investigate the allegations against that person and to adduce evidence against that person's labeled allegation, and that person shall be represented in that tribunal to prove whether indeed the allegations leveled against that person are substantiated or not. And if substantiated, then of course, their removal shall be what? Shall be effected. So the Secretary to the Cabinet, Mr. Aaron Muna, working together with the Permanent Secretary in the Ministry of Education at the time, wrote to the Teaching Service Commission with their allegations against Mr. Bedford Chirusha Kangombe and requesting the Teaching Service Commission to set up a tribunal to probe the alleged involvement of Mr. Kangombe in political activities of the opposition political party. The allegation was received, the evidence was received. However, the findings of the tribunal were that there was no evidence really to substantiate the allegations that have been leveled against Mr. Kangombe by the Secretary to the Cabinet and the Permanent Secretary of the Ministry of Education. And they wrote, the tribunal wrote back and said, we cannot find anything really to warrant the dismissal of Mr. or to recommend the dismissal of who? Mr. Kangombe. What we therefore recommend here is that since Mr. Kangombe has been suspended, he'd be reinstated. But if you do not want him to go back to the school, Mr. Kangombe should be reinstated and deployed to the Ministry of Education offices, where he can get close monitoring of his activities. Of course, that is not what the government wanted. They wanted Mr. Kangombe to be dismissed. They wanted to use him as an example. So the Secretary to the Cabinet and the Permanent Secretary wrote back to the tribunal and asked them to reconsider, their findings of allegations against Mr. Kangombe. So what has to reconsider? Let us go through again. They went back and checked and said, well, there's nothing still we find that would warrant the dismissal or recommending the dismissal of Mr. Kangombe. So again, they wrote back, and the same recommendations they made second time around. With that, Mr. Secretary to the Cabinet, Aaron Milner, together with the Permanent Secretary, saying, all right, here, the only thing is we write to the President. Let us write to the President and ask the President. After all, he has the power to fire. Let us write to the President and ask the President to just dismiss Mr. Kangombe. And they wrote a letter. And in that letter, it says, it is according to the Secretary to the Cabinet. According to me, this gentleman's journey in the public service right now has come to an end. And I recommend Your Excellency that you dismiss this person. Well, President KK received that letter, and within 2 days, he wrote a letter of dismissal. And Mr. Kangombe was dismissed with immediate effect. Of course, he sought legal advice against his removal. The contention he had was that his removal was ultra virus on the basis of procedure. His contention was that the correct procedure had not been followed in his removal. That was number one. Number two, he contended that there was a breach on the principle of audi alteram partem. There was a breach on the principle of audi alteram partem, which simply means the rules of natural justice of saying no one should be condemned without being given an opportunity to be heard. Audi, that is A-L-D-I, audi alteram, A-L-T-E-R-E-M, patem, P-A-T-E-M, audi alteram patem. No person should be condemned without being given an opportunity to be heard. So members, it is 4 o'clock. So what we are going to do is, I'll let you now go and read this case. That's what. Find this case of Bedford Chirufya Kangombe versus the Attorney General. The judge who presided over that case later became the country's Chief Justice, His Lordship, Mr. Aneo Silungwe, passed on sometime early this year at a very ripe age of 90-something. His Lordship, Mr. Justice Aneo Silungwe. He was then High Court judge at the time, 1973, when he ruled this case. All right, so we end our lecture now. I will let you go and find this case. Next week, Monday, when we meet, we shall be discussing the case of Bedford. So go and look at reread. I know I have already narrated, but go and reread the facts. Find the decision made, find the rationale behind the decision made. These are important points in law. Find the decision, find the rationale. Don't just find the decision, find the rationale. The rationale is what we refer to as what, members? According to your legal process class, what is the rationale? The ratio, isn't it? The ratio dissidenda. The reasoning behind the decision made. Okay, do we have any questions here, physically members or friends online? Has anyone any question at all? No question from Angel there. Heather and Nicolette, do we have any questions at all? No question from Heather there. Nicolette, do we have a question? Nicolette, do we have a question? No, Nicolette does not have a question either. All right, members, so we have come to the end of our lecture for today. Please go and read through the case. We shall come and discuss it on Monday next week. For now, enjoy the rest of the day. The weather is not bad today. The weather is good. So you can have fun. It's not hot. It's not cold. It's just. And I pray that soon